Good morning, everyone. I'm Nicholas Leviseur, and I'm delighted to welcome you to the webinar which we're holding this morning. I'm delighted particularly that so many of you have been able to come in from the garden to pretend to do an hour's CPD. Very good news that you're so conscientious. I hope that what will unfold over the next hour or so will be a fairly wide-ranging exploration of the opportunities that the lockdown and the pandemic will offer to us, and perhaps more importantly, to all our clients. I'll be looking at the overarching scheme of the regulations. Daniel Johnson, who's head of regulatory law at Stephensons, will follow me, and he'll look at the specific area of dentist and dentistry. And I might add that I'm pretty anxious to hear what he's got to say, since my wife, as a dentist, is busy struggling with these regulations at the moment. And then Daniel will conclude with a look at what is likely to come our way, at least in terms of the regulatory field, over the next few months. And I hope we'll have some words of both warning and opportunity for us all. Well, if I can begin with, as I say, the overarching scheme, and bring up for your edification the health protection coronavirus restrictions, brackets England, close bracket, regulations of 2020. They came into force at either 12 a.m. or 12 p.m. On the 26th of March 2020. That's a really, really significant matter because it's not at all clear, actually, whether it took effect at noon or otherwise. And there is a lacuna in the regulations and a straightforward defence for any offences committed within the first 12 hours of it. These were made by the Secretary of State for Health and for Social Care, that is to say, Mr. Hancock, not by anybody else and not by the government. They were made specifically by the Secretary of State. They were made under Section 45R of the Public Health Control of Diseases Act 1984, and it would be fair to say that nobody at all knew that Mr. Hancock had any such power to do this, and it never crossed anyone's mind that it was permissible to shut down the country under a little-known provision of an act which had never, up to that stage, been used. So extraordinary was the situation that these regulations were not laid before Parliament, and they were not approved by reason of urgency. That urgency certified by the Secretary of State, the very man who made the regulations. If you want a textbook example of how tyrannical regimes can come into being, set yourself up in the following way. Give yourself powers under an act that nobody thought applied. Allow yourself to certify that by reason of urgency, they don't have to be approved by anyone, and then bring them into immediate force. Extraordinary provisions for extraordinary times. The framework, which can be very simply explained, goes something like this. The first 3 paragraphs of the regulations are citations, interpretation, the length of the emergency period, and matters of that sort. Paragraphs 4 to 5 deal with the closure of premises, and Schedule 2 provides what businesses are subject to restriction or closure. Paragraph 6 deals with restriction on movement, and paragraph 7 and 7A on the restriction on gathering. Paragraph 7A is lately come to the field, and one of the things that's important to understand with these regulations is they've been amended a lot with no notice. What happens is that the Secretary of State makes an announcement, or the Prime Minister makes an announcement, and almost always the regulations do not appear on the government website until 8 or 10 hours after the event, because the parliamentary draftsmen are still trying to work out what to do and how to do it. And that explains why the regulations in some cases haven't worked, and in other cases don't work very well. Paragraphs 8 to 11 deal with enforcement, penalties and prosecutions, and are again, very, very wide-ranging indeed. Noticeably, the powers to punish at the end of the day are given either to the police or to local authorities, and in the last resort, reviewed by magistrates' courts. My general advice to anyone is simply refuse to pay up. Almost certainly they'll have got it wrong. And I don't know of any cases where fines have actually been imposed by magistrates' courts. They're subject to judicial review in the usual way, and almost every one will be struck down for reasons that I can deal with a little later. There are two schedules. The first schedule deals with underlying medical conditions. It's got longer and longer as people have woken up to the effect of the virus, and so things that you now know affect us are included, whereas in the past they weren't. And Schedule 2, as I say, deals with businesses subject to restriction or to closure. What I want to do is just give you an overarching view of what the original scheme was, because it doesn't apply anymore. The original scheme was that everyone was prevented from leaving their home without reasonable excuse. And it can be put as bluntly and straightforwardly as that. All places of public entertainment and worship were shut. So cinemas, churches, bingo halls, massage parlours and nail bars. All shops were shut unless they sold food, drink, newspapers, or what can loosely be called do-it-yourself, rather glumly described as items necessary for the repair of homes and premises. All hotels and like establishments were closed, so Butlins holiday camps and so on and so forth were all shut. It's probably worthwhile just pointing out that the reasonable excuse regulations were very, very widely drawn, so that a reasonable excuse for leaving your home was to go to work. It's perfectly true that you were exhorted not to go to work, but if you wanted to go to work and your work couldn't reasonably be done from home, which frankly is the case of almost all work, you could leave your home. You could leave your home for the purposes of exercise, and I ought to break it to you that the actions of the Derbyshire police were unlawful. Quite why the people they arrested haven't got a huge payout, I don't know, but anyone in that area, get on to them, you can make some money for your clients. It was permissible to leave your home for any length of time, on any number of occasions, and to drive wherever you wanted to, anywhere in the country to take exercise. So for those of you who really wanted to do the Three Peaks but lived in Bournemouth, you could drive up there, climb Pen y Ghent, and on you went to Ingleborough, and it was all perfectly lawful. It's not what the government said the rules were, it's just that's what the law was. And of course, you were permitted to provide care for others, so that if you were minded to go and see your parents who lived anywhere, it was perfectly possible to do that, and perfectly proper. If they were over the age of 70, they were deemed to be vulnerable. If anyone was pregnant, they too were deemed to be vulnerable, and a very large number of other people were deemed to be vulnerable, including any of those who received care under the relevant acts. And you could go and see them without any let or hindrance. You could even stay overnight if you wanted to with them for the provision of care. And so coach and horses could be driven through the regulations, and you didn't commit an offence. Now, the present scheme has changed. There is now no control of movement. So anyone may go wherever they want to do whatever they want. There simply is no control of movement. There is control of association, with exemptions for those who live together, or more recently for those who live in what's called an associated household. No one can gather outside with more than 6 people with a common purpose. So that if you happen to be a rioter in Bristol, it was actually quite unlawful, and you had no business doing that, as everyone well knew. However, if you happen to be walking in a park with 6 of your friends, and a load of other people with no common purpose at all attended for the same reason, but unbeknown to you, you commit no offence. So as long as you keep your group to 6, you can actually be with as many people as you like in public, so long as you don't have a common purpose. No one may gather inside with anyone at all for a common purpose. That's the restriction, and that it is that prevents people from staying overnight and moving in with other people. It doesn't stop you going into someone's house, for instance, to go to the lavatory, because unless you are a complete pervert, that's not a common purpose. You're clearly not going to be going to the lavatory with someone else. And for those reasons, you can go into people's houses so long as you don't sit down for a meal or do something like that, unless you are there for an exempted purpose, and the exempted purposes continue to be extraordinarily wide. Those of us who attend upon clients are there for a purpose. It's an exempt purpose, and there's no reason why you can't join people, even for a meal, and you could indeed stay overnight for legal purposes. Shops are open, and shops of whatever variety are now open. Places of worship are open, but can't be used for corporate activity. A great deal of thought has been given by this, but my own personal suspicion is that the reason that places of worship were shut and shut so quickly and so fast was not to provide an inhibition on Christians or Jews, but it was to prevent mass gatherings during Ramadan. And the fear was, and articulated by at least 2 members of government, the fear was that too many people would gather, particularly to celebrate after the hours of darkness and to eat together. And in those circumstances, there was a real fear that there would be contagion which simply could not be controlled. And it was for that reason that places of worship were shut down so very quickly and in such a draconian way. Now, as to the future, well, the Prime Minister, in his statement to the House of Commons, in a line which has received almost no attention, said that we will be moving from regulation to guidance. And this may be of very, very great significance. It seems to me clear that what is about to happen is that the regulations are going to go and exhortation will take its place. Now, I just want to say a couple of things about reasonable excuse and guidelines. No one's obliged to do anything except by force of law, and the law in this respect is set out in the regulations, as they've been from time to time since the 26th of March. Guidelines, briefings, exhortation, thoughts of the Prime Minister, thoughts of chiefs of police, the exhortation of government scientific advisors have precisely no effect in law at all. And when considering the duties of care that employees have, or the duties that service providers have, you can have recourse to the guidelines, but the guidelines are just that. The principle must always be to follow the evidence base, and that may have little to do with the guidelines. They are exhortatory. An area which was particularly difficult to justify, which can't be found in the regulation, is the 2-meter rule. It's not a rule, and the World Health Organization has repeatedly said it actually ought to be a meter. The evidence to support this comes from a still air laboratory experiment, which concluded that inside buildings, 3 feet is the distance over which droplet infection attenuates. So a second area of considerable difficulty is what's come to be known as shielders. These are the old and the sick who've been placed under house imprisonment and subject to control of association. There's no basis for this in law at all. The entire concept is exhortatory, and anyone who chooses to do so can do what everyone else does and simply go outside. There is no basis in law for this at all, and I suspect lawyers may need to look at this quite carefully in future. Reasonable excuse. The restrictions on movement and association are very, very wide. And the good news is that Mr. Cummins was perfectly entitled to do as he did. Crucially, the list was non-exclusive, and the regulations simply provide that some things are deemed to be reasonable. In his particular case, he had the healthcare excuse, I'm delighted to say, for his parents who were over the relevant age. He had the childcare excuse, which is specifically
Everyone. Nicholas seems to be having some technical difficulties, so I will pick it up from here now, and when Nicholas is able to rejoin us, we'll see if he has any further comments to make. As Nicholas outlined at the beginning of this talk, this part of the talk is going to focus on the opportunities which are likely to arise as we see a continued relaxation of restrictions and the regulatory and compliance burden faced by those professionals who seek to take advantage of these opportunities. Now, when we planned this webinar, it was intended that this section would talk about the healthcare sector generally. However, as has been a running theme during the pandemic, the best laid plans are very quickly overtaken by events, and no sooner had we agreed upon a topic than there were important developments within the dental sector, and as such that's going to be the focus for today's talk. Now, in general terms, I recognise that it may sound somewhat cynical to be speaking in terms of opportunities in the current climate, but as advisors to regulated clients in the healthcare sector, I think it's important that we recognise that while our clients are providing an invaluable public service, those practitioners working outside of hospital and large care provider settings are often working in privately owned small businesses and are facing exactly the same anxieties as other business owners as a result of lockdown and the associated drop in activity. The obvious examples being independent pharmacies, GP surgeries, and dental practices. Many of these businesses will obviously be keen to resume their normal operations as soon as it's feasible to do so. Key thing to take away from today's talk is that when doing so, it is vital that they adhere to the raft of guidance and issued by their regulators and organisations such as NHS England. Now, in terms of the differing experiences of these businesses today, well, clearly with regard to pharmacies, these pharmacists and their teams are a frontline service, and as such, most have remained open throughout lockdown, albeit on a limited basis and or with intermittent and temporary closures, so as to manage the risks. The GPHC and the Royal Pharmaceutical Society have been very good, very active in terms of issuing guidance to their members in terms of how to adapt one's practice to cope with the challenges posed by COVID-19. A key example being increased emphasis on delivery of prescriptions as opposed to collection, and where possible, the use of NHS volunteers to facilitate this. In regard to GPs' practices, well, this has perhaps to some extent mirrored the experience of professional services businesses, in that while some routine work has clearly been put on hold, as much work as possible has been dealt with remotely, whether via online consultation or via increased home visits. Online consultations have been commonplace through lockdown, and the GPs who I've spoken to over the last couple of months have found this to be both workable for them and their practices, and most importantly, well received by most patients. So as with the experience of professional services firms, it remains to be seen whether this practice continues to be widespread, where safe and appropriate to do so, even after we emerge from the crisis. Really whether this does signal a new way of working for GP practices. And I think it's fair to say that from a commercial perspective, the greater use of online remote consultations may go some way to help shield more traditional practices from the increased competition that they're now facing from the proliferation of online providers that we've seen in recent years. But for the time being, at least, NHS England has made clear in guidance that all care that can be provided remotely ought to be. Then we come to the issue of dental practices, and as many of you will be aware, on the 25th of March, the Chief Dental Officer for England announced that all routine, non-urgent dental care should be stopped and deferred until further notice. Practices were asked to establish remote urgent care services providing telephone triage for patients with urgent needs, and practices were asked to establish networks of urgent dental care sites for face-to-face care where this was an absolute clinical necessity, so we're talking about emergency care only. And it is fair to say that this has proved controversial across the sector. Those of us who act for clients within the dental profession will be well aware of the strength of feeling over this issue, the real frustration at the level of restrictions imposed and hardship that's resulted from this. And of course, the impact upon on patients and the oral health of the nation, as it were. Questions were understandably raised about whether this was a proportionate response. So where are we now? Well, on the 25th of May, CDO issued a further letter titled The Resumption of Dental Services in England. This asked dental practices to commence opening from Monday 8th of June for face-to-face care, provided, and this is important, that they assess that they have in place the necessary personal protective equipment and infection prevention and control measures. It's important to note that the procedures which have subsequently been set out are very onerous and, frankly, will have real financial implications for practices. And I think it's fair to say that in some cases with smaller practices, these requirements may be so onerous that it isn't actually practicable for them to resume their operations at this time. So what are those requirements? Well, NHS England subsequently issued the standard operating procedure transition to recovery document, the most recent update to which was on the 17th of June. This sets out some key principles and the steps which are going to be required by practices to ensure that they are compliant. So in terms of the key principles, very briefly, the guidance makes clear that it is envisaged that this will be a phased return to normal operations. During the initial resumption, which is the phase that we are in as we speak, the expectation is for practice-based urgent dental care only. The subsequent pace of progression towards the full range of routine dental care will need to be risk managed by individual practices and obviously at regulator level. And as such, this document makes clear that practices should continue to offer remote consultations wherever it is possible to do so. And any patients requiring urgent face-to-face care should be triaged remotely to establish the actual degree of urgency before doing so. The most important part of what is a particularly lengthy document, 61 pages in all, but I think really the meat of it can be found in Appendix 1, and that's the Public Health England guidance for infection prevention and control in dental care. This really sets out the standards against which regulators such as the General Dental Council and the Care Quality Commission should assess compliance with the requirements for the delivery of safe care. So really these are the standards against which a practice and or practitioners are going to be judged for the purposes of inspection regimes and, if appropriate, fitness to practice proceedings. So it's important that all practices and those who advise them are aware of these requirements. In terms of the standing from a regulatory perspective, the CQC in their most recent update to the dental sector have made clear that when they consider the extent to which a provider is providing safe and effective care, they are going to have regard to guidance from Public Health England, the Chief Dental Officer and the General Dental Council. The GDC's statement on regulation during coronavirus simply adopts the joint statement from the Chief Executives of Statutory Healthcare Regulators, making clear that when they judge and evaluate the context of an allegation, they'll take into account relevant resources, guidelines and protocols in place at the material time. So that's really the regulatory standing of this standard operating procedure. Now, I'm not going to go through each and every requirement, as exciting and interesting as I find it. I recognise that not everyone in attendance today will do so. And given that it is a rather lengthy document, we could be here a lot longer than 15 minutes. But really, I just want to summarise some of the key areas, just to give you a flavour of the sort of requirements that A, are being imposed on dental practices right now, and B, that we're likely to see in other settings moving forwards. The guidance is split into a number of key headings, and I'll summarise some of the most important areas. So in terms of patient assessment, obviously patients who are shielding or who are, patients who are shielding should be treated separately to other patients. Patients who are positive or suspected cases for COVID-19 should be discouraged from attending a practice altogether, unless they cannot be treated either by remote means or by an urgent treatment hub. And only then should they be allowed into the practice, and they should be treated separately from the main list. If common waiting areas are to be used, practices are advised to consider providing patients with surgical masks when in the practice. In terms of practice settings, before beginning this process of resuming ordinary activities, all practices, as you would expect, are required to complete a risk assessment, and that includes a walkthrough of both patient and staff areas to identify any changes which may need to be made to practice layouts to support social distancing measures. This is one of the things that's going to be quite impractical for smaller practices who perhaps don't have the luxury of a great deal of space. The guidance asks practices to establish single entry and exit points for patients with alcohol hand gel available at each, and it sets a requirement for measures to reduce reception interactions. So that's facilities to book appointments online, facilities to book appointments via email, perspex shields to create physical barriers for reception desks, and use of contactless payment wherever possible. All practices are required to have and follow standard infection control precautions, and it is important that these are strictly adhered to at all times with all patients, irrespective of their level of risk. All practices will need to have transmission-based precautions in place to prevent and control infection via contact transmission, droplet transmission, and airborne transmission. Then we get to aerosol generating procedures, which are obviously one of the key risk areas for dental teams. High-speed dental devices such as drills, scalers, the use of high-pressure air will generate aerosols capable of causing widespread environmental contamination. This is one of the key risk factors which prompted the quite arbitrary restrictions that were imposed on dental practices. And this standard operating procedure makes clear that AGPs can be carried out now where it is clinically necessary. So where possible, they should be avoided, but where it is necessary, they are permitted. Obviously, the question of necessity will be down to the individual practitioner. The standard operating procedure says that practices need to aim to complete a procedure in a single visit wherever it's possible to do so. And there will be very strict PPE protocols for AGPs over and above the usual PPE protocols for other areas of dental care. So this is going to include fluid repellent disposable gowns, gloves, eye and face protection, respirator masks to be used both by those undertaking the procedure and those assisting. And where a member of staff can't wear a respirator mask, for example, due to facial hair or religious headdress, they need to be wearing something like a surgical hood with a face shield. So these requirements really are quite onerous for obvious reasons. In addition to the PPE protocols, the IPC, Infection Prevention and Control protocols are equally strict. And where an AGP is carried out, there's a recommendation that a room is left vacant for an hour before cleaning if it's a neutral pressure room. So this is going to really limit the ability of practices to carry out anything like their normal level of practice. There are the usual requirements which we've come to expect now in all health settings regarding hygiene. So patients will be required to wash their hands or use an alcohol-based rub when entering and leaving the practice. Staff will be required to wash their hands immediately before treatment and immediately after any activity where there is a risk of contamination. So that's putting on and removing PPE, equipment decontamination, and waste handling. And finally, quite an important area, staff wellbeing. There's a lot of detail in terms of the requirements on practices for staff wellbeing. And that's over and above things like ensuring that there's adequate PPE available at all times. Obviously, as part of the risk assessments that need to be carried out, risk assessments should be conducted for each member of staff. Those who are deemed extremely vulnerable should not be returning to work during this transition period. Those who are determined to be vulnerable may need to be redeployed to non-clinical duties for the time being, at least. It goes without saying that staff who have tested positive for COVID-19 or who are symptomatic should not be anywhere near the practice until they've self-isolated. We'll also need to be training of all staff within a practice, so that's training on the use of PPE, what type should be used in each setting and context, all aspects of infection protection control measures. Cleaning staff also need to be trained in these measures as well, because they will play a very important role in preventing contamination and infection, and the guidance requires educational posters to be placed around practices to remind and assist members of staff. And as a final but equally important point, the guidance makes clear that practitioners need to be mindful of staff mental health. It goes without saying that this is a period of heightened stress and anxiety for many healthcare professionals, and the steps that are required under this standard operating procedure may well heighten this stress and anxiety. Dental practices are going to be very unfamiliar and unwelcoming environments for the time being, at least. And this needs to be borne in mind in terms of the impact that it will have on staff. So practitioners are signposted to the guidance issued by NHS employers, NHS Practitioner Health and the British Dental Association on these points. So just to conclude, really the key point to take away from this section of today's webinar is that this gradual relaxation of restrictions associated with the management of COVID-19, it is going to create opportunities for practitioners to begin the process of returning to normal operations. However, we are a long way from business as usual. We should expect that the requirements placed on healthcare practices will continue to be onerous for some time. Practices and practitioners are seeking to resume normal activities to the extent that they're committed to do so, are advised to do so cautiously and ensure strict compliance with the guidance that's published. And they need to ensure that they keep up to speed with this guidance as it continues to evolve. One of the key phrases, which I'll finish with, jumped out at me from the introduction to the standard operating procedure was the following. It says that central to the phased transition of dental services and the resumption of all service provision is the acknowledged clinical judgment of practitioners and their ability to risk manage the delivery of dental care. Now, at first blush, that might sound like a compliment or an example of common sense regulation, but as someone who is a defence lawyer for regulated professionals, that does read rather ominously. Because if and when things do go wrong within dental practices, and it's fair to say that practitioners can expect to have their clinical judgment and their ability to risk manage very closely questioned and scrutinised. And we can expect the principles that we've discussed this morning to appear in CQC inspection reports and professional disciplinary cases before the GDC. Okay, well, thank you very much for listening. Now I'm going to hand over to Daniel.
Thank you, Carl. Carl and Nicholas, both of your talks have really set the scene for what I'm about to discuss in setting some of the challenges that healthcare professionals are going to be facing for quite some time. But more broadly, if we take a step back, I don't need any authority to say that it's now clear, it's public knowledge, that doctors, nurses and other professionals are working in circumstances where there is huge pressure. They're working at or beyond their level of competence in some cases, and in circumstances where there are real shortages of PPE. And these concerns apply across all settings, hospitals, care homes, and in the community more generally. So the first question I'm going to ask is, what do the regulators have to say about all of this? How are they going to regulate effectively in these circumstances? After I've looked at that, I'm going to refer to the case law on misconduct, and I'm going to suggest that in fact there is reason for optimism, and the case law should be a source of reassurance for medical practitioners practicing in the circumstances of the pandemic. And then finally, I'm going to look at the question of the public interest more broadly. Things like clap for our carers exemplify the new public attitude or appreciation for healthcare professionals, what implications could that have on fitness to practice proceedings more generally? And through this talk, I'm going to be focusing on the position in relation to doctors and nurses. However, much of what I say will have broader application. In terms of then, what are the regulators saying? The starting point must be the joint statement from the chief executives of health and care regulators. And that joint statement makes a number of helpful observations. For example, it states that professionals may need to depart from established procedures in order to care for patients. So it's a good thing that that has been recognised. And similarly, it goes on to say that regulatory standards are designed to be flexible. Again, flexibility is going to be very important in this pandemic. However, it does go on to say that practitioners must keep in mind the key principles. And one of those principles it refers to is the need to recognise and work within the limits of one's own competence. And that last point, working in the limits of one's own competence, is something that is made very clear in good medical practice, for instance, in relation to doctors, and in the NMC code in relation to nurses. Indeed, while both doctors and nurses and other professionals have a duty to assist in emergencies, they must always consider the limits of their own competence. And in respect of nurses, the NMC code in particular is explicit. Only act in an emergency within the limits of your knowledge and competence. And it's unclear really how all of that is going to sit with the reality on the ground, where doctors and nurses and others are being put under this huge pressure and thrust into unfamiliar settings. On this issue, all the regulators have produced guidance on their websites of an informal nature. The GMC has some FAQs and some answers. One of those questions is, what if I'm asked to work in a different speciality or outside my competence? And the answer is just this. All doctors have a duty to recognise and work within their competence. But in these exceptional circumstances, doctors at every level may be required to work at the limits of their comfort zone, and in some cases beyond. It's right that the guidance does go on to refer to the specific considerations that doctors ought to consider. For example, what expertise is there within the team more broadly? What skills can others bring to bear? The need to identify and undertake any appropriate training where possible, and to know who to go to for support and advice. But another of the questions on the GMC's FAQ page asks if the GMC would be able to specify some scenarios and provide a bit more concrete advice. And the answer is essentially no two sets of circumstances are the same. We will have to look at the specifics of any concern raised with us. We do not speculate on scenarios. And so ultimately, it seems that healthcare professionals are going to be making decisions which are unfamiliar to them under huge pressure, and they're going to have to use their professional judgment. Both the GMC and the NMC, and no doubt the other regulators, encourage practitioners to record any concerns they have about working outside of their competence and the associated risk to patients. And of course, that's a very important thing to do in general practice, and will be all the more important now. But will that be enough? Will the regulators be quick to pounce on any judgments that, with the benefit of hindsight, might be seen as wrong? Well, I think the regulators are going to be wary of the risk of adverse publicity. They're not going to want to be seen as being overzealous or out of step with the profession. And to touch on just a couple of examples, there's the GMC case of Dr. Baragaba, where the GMC sought to appeal a decision of the Medical Practitioners Tribunal Service, which, rather than erasing or striking off a doctor, imposed a suspension in the context of a conviction for gross negligence manslaughter. That attracted quite a lot of publicity that was adverse to the GMC. In a different context, in the NMC, there's a case of Pauline Kafaki, who was a nurse who, abroad, overseas, assisted with Ebola. And on her return to the UK, an incorrect recording of her own temperature was made. That resulted in allegations of dishonesty being levelled against Miss Cafferty, and therefore in fitness to practice proceedings in Edinburgh by the NMC. Ultimately, again, there was significant media attention on that, and the NMC ended up offering no evidence on the dishonesty, accepting that the Ebola situation, the impact it would have had on Miss Kafka's health, and indeed the exhaustion she would be feeling, would have been relevant to her state of mind. And the panel decided that there was no misconduct. But perhaps a sign of just how high profile that was is the same day, just after that decision was handed down, a tweet from Nicola Sturgeon came in support of Miss Kafka. So these are high profile issues. And as I say, regulators will be keen to ensure they do not come across as overzealous and on the wrong side of the debate, as it were. But nevertheless, taking all that on one hand, the point remains, these are matters of professional judgment. Situations doctors, nurses and others find themselves in will be extremely difficult. And those professional judgments, in my view, are likely to be called into question. We are therefore, in my view, likely to see a significant number of COVID-related fitness to practice proceedings, in particular, allegations of misconduct. So that's what the regulators say. That's what I anticipate the position will be over the coming months and possibly years. But there is cause for optimism. And I say that because the case law, I think, really should provide some reassurance to anyone acting for a health professional and indeed the doctors and nurses themselves. And I don't need to refer to any particularly new or obscure cases, but I'm going to refer, in fact, to one of the most well-known and often cited cases in misconduct proceedings. It's that of Roylance and the General Medical Council number 2. And the often quoted definition of the word misconduct in the context of professional regulatory proceedings by Lord Clyde is this: misconduct is a word of general effect, involving some act or omission which falls short of what would be proper in the circumstances. That's the first part, what would be proper in the circumstances. The second sentence is, the standard of propriety may often be found by reference to the rules and standards ordinarily required to be followed by a medical practitioner in the particular circumstances. Now, in my experience, it's all too common for tribunals or panels assessing misconduct to go straight to the guidance, straight to the written standards, to good medical practice, to the NMC code and other published written standards, and to treat any circumstances existing at the time, staff shortages and so forth, as being mere points of mitigation. But in my view, that's quite wrong. The test for misconduct necessarily requires the tribunal or the fact finder to assess what were the circumstances in which practice was being undertaken, in which the conduct took place or the omission occurred, and what would be proper in those particular circumstances. That is central to the issue. And indeed, the point is made again, perhaps even more plainly, in the case of Campbell and the General Medical Council, in which the court said this: the error under consideration may need to be examined in the context of a dedicated practitioner working in isolation and under huge pressure of, say, an epidemic. Such circumstances may be relevant to the question of whether he should be found guilty of serious professional misconduct. And so the point is, putting matters another way, you get 2 bites of the cherry. In the context of a pandemic, staff shortages, the requirement to work at the limits or beyond one's competence, issues with PPE and so forth, are central to the question of whether what a practitioner has done or not done falls below or far below, as the law requires, the standards that would be expected in the circumstances. So there's a reasonable argument that when you're under such huge pressure, ordinary standards are not necessarily going to be met or required. And of course, if that argument fails, all of those circumstances will be mitigation in relation to any sanction that the tribunal or panel might be seeking or considering imposing. So I say for those reasons, the case law does provide some degree of reassurance, and regulators drafting allegations will have to be aware of that test of misconduct and take account of the context of the pandemic. Similarly, anyone representing doctors, nurses, or other professionals should be reading any decision on misconduct with care. And if the decision does not show that the panel or tribunal has taken account of the external circumstances when deciding on what the standards appropriate were, that is, when deciding whether misconduct is established, then such a case will be ripe for appeal. It is not enough to simply take those matters into account when looking at sanction. And so I say that should provide some reassurance to practitioners. And moving on then to the final part of my talk, which is the public interest. Public interest is something that has to be considered throughout all stages of the fitness to practice process. It's relevant, for example, when a panel or tribunal is considering whether to impose an interim order. It's also relevant to considering whether a tribunal should find impairment of fitness for practice, and of course it's relevant to sanction. And it's been long established that there is a public interest in the return to practice of a safe or competent practitioner. However, in the past, very often, that public interest has been trumped by what is said to be the public interest in declaring and upholding proper standards, or indeed protecting the reputation of the profession and the regulators more generally. But in the light of overwhelming public support for healthcare professionals, I say or suggest that in fact that balance could be shifting. The mood music has changed, and it provides a real opportunity for practitioners to be arguing that the public interest is in favour of them returning to practice. And quite recently, there was a case of a doctor who was a consultant in an intensive care unit who had been suspended in relation to working both for an NHS and at a private hospital, or rather being on call for both, on 33 occasions. He had been suspended, but in light of the pandemic, his employer wrote to the GMC in these terms: I need every consultant I can get, let alone clinically excellent colleagues like this particular doctor. And in revoking the suspension, NPTS held that the balance was in favour of allowing the registrant to return to practice as an ICU consultant in order to help address the public health crisis. And so this argument, I say, is likely to be available to many practitioners who are currently serving a public interest only sanction, a public interest only suspension, for example, and particularly those with a supportive employer. Anyone in that category who wishes to return to practice now, particularly if their role would involve working closely in relation to the pandemic, really should consider whether they have grounds to apply for an early review and seek revocation of that suspension order. So, as I say, the case law does provide some support, and the shift in public attitudes, or rather the renewal of public appreciation for healthcare professionals, really does provide an opportunity to shift the balance of the public interest and how that is applied in these proceedings. So that's all I was proposing to say. I might hand over to Nicholas if he has any further comments.
Thank you very much, Daniel. Can everyone hear me? No. Can everyone now hear me or not?
Yes.
You can, good.
Yeah.
I just wanted to add one thing about the Human Rights Act, an act of Parliament that I loathe and detest, but for these purposes, I think it's right that I bring it to everyone's attention. Derogation from the Act is perfectly reasonable and proper. But as you recollect, right at the start, I said that in fact this was laid by the Secretary of State to Parliament, together with a statement that no assessment had been done at all about its secondary effect on engaged rights. Now, the tests are of proportionality, necessity, and reasonableness. It's very difficult to see if some of these tests are met, and it's extremely difficult to see what the evidence base is for some of the draconian restrictions. And I wonder if that's why the drafting has been very much looser on permissive scope than many think, and why there's been so much emphasis on guidelines, which by constant repetition, many of us, including those who ought to know rather better, have taken to be the law. I think there's fertile ground here for a lot of us to engage the Act, and particularly engage it when we're thinking about our regulators and say, no, quite a lot of things that have happened have not been proportionate and reasonable, and we've been, as it were, offended against. Entrenched rights ought to have been looked at, and they haven't been. And one thing I want also to add, which is that there are some regulators who have been absent, conspicuously absent. And I know Carl was thinking about this, but my own views about the CQC and to some extent Ofsted are that they have been pretty seriously absent from much regulation. And I think that's going to be a fertile area of excuse and explanation as well, when the inevitable consequences of what's happening in care homes start to be litigated about. Carl, are there any questions that you think arise that we ought to deal with? There is certainly one obvious question, which is, gentlemen, do you think there's going to be an uptick in disciplinary work as a result of the fallout from regulations, guidelines, and general pandemic uncertainty? What's your view about that?
Should I start?
Yes.
Well, I think our experience really of professional discipline work during the pandemic has been twofold. Anything substantive has been kicked into the long grass. Anything that was required to proceed due to a statutory provision, the obvious examples being interim orders and reviews of statutory orders, have still proceeded by remote means. So when we begin to emerge from these lockdown restrictions, there's already an enormous backlog of substantive cases that are waiting to be dealt with. So professional disciplinary regulators are going to be incredibly busy as soon as the taps are turned back on, as it were. Then, yeah, it's clearly we would expect an extra layer of new cases which arise from the issues that practitioners have faced during the pandemic. And one area which could prove to be quite interesting is all of the former professionals who have been allowed back onto temporary registers during the pandemic to help the NHS cope with the increased demand, and whether errors, mistakes, misconduct is more commonplace in those who've returned to temporary registration. So I think that's going to be an interesting area to look at. But to answer the question in very general terms, do we expect professional disciplinary regulators to be a lot busier as we come out of this? Yeah, definitely yes.
And if I pick up, I agree with everything Carl has said. I certainly agree there are likely to be a large number of referrals to regulators, a large number of concerns being raised for them to consider. As I said, I think it will be, time will tell how the regulators decide to apply what they would see as the public interest in proceeding with those matters in light of the difficult circumstances professionals are under, and the need to be aware of not having a backlash from the professions themselves. So I think we will see a large number of referrals. I think it's going to take a while for these cases to work their way through the system, not least because, as Carl said, very few substantive hearings or trials effectively have been taking place. Really, it's only been interim orders and reviews of substantive orders, such as suspensions and so forth. So even when all of the restrictions end, as Carl rightly says, there is a huge backlog. And so I think we can expect to be dealing with COVID-19 related cases for the foreseeable future, certainly over the next couple of years at least.
Thank you. That's very helpful. I want to add a couple of things. When will we start to get, the question is, when do you think we'll start to get the first of the High Court steers on this? And it seems to me the answer is not for at least 9 months. Daniel, do you want to say yes or no to that?
Yes, unless we're talking about interim orders. I think that there's some potential for that to move quickly.
Yeah. Main themes, I think the main theme is going to be the justiciability and the evidence base for the guidance. Regulations are easy, but this is guidance that we're going to be looking at so much of the time. People are going to be criticized for not following the guidance. And the short answers be, it's not law, it's guidance. What's the evidence base? And I think that's going to be the interplay. There's a very interesting question which has clicked through, which I'll sling out to all of you. Carl, you can take the lead on this one. What do you think the attitude of insurers is going to be? Those generous people who fund without any kind of inhibition all litigation that is brought to their attention. What do you think the attitude of insurers is going to be to this sort of professional disciplinary work? Taps on, taps off? Carl, you can begin.
It's a tricky one because under the generally when you see a professional disciplinary case or a regulatory CQC case funded by an insurer, it's coming down to the policy wording that was in place in relation to that particular policy in that case. So the obvious examples being convictions for violent offences, allegations of dishonesty are routinely excluded. So if the policy wording protects a professional, there shouldn't be anything about COVID. If you're dealing with a competence issue or a professional misconduct issue, just because the context is related to something completely out of the ordinary doesn't necessarily or shouldn't necessarily render a claim null and void if the substance of the claim is covered by the policy wording. That would be, as someone who does a lot of defence work for legal expenses insured clients, that would be my hope anyway.
Yeah, thank you. I think from the coalface, that's pretty helpful. I mean, certainly I know in commercial terms, insurers have not been generous in their scope of wording, and they tend, if they possibly can, to restrict, as Carl says, to the strict wording of the clauses, and I think that's what we'll have to look at. We've got a very interesting question here. The evidential basis. You criticise the evidential basis for some of the guidelines. However, precautionary measures usually involve a margin of safety, which, as any engineer will tell you, is just actually a margin of ignorance. Do you have any views in this in relation to the 2-metre guidance? Well, I think I've made my position pretty clear about 2-metre guidance. There's no basis for it whatsoever. And if you really want to think about it, 2 metres is 6 foot. 6'6" and just over 6.5 inches, which is why in the United States of America, of course, it's a 1.80 rule. It isn't actually; it's a 6 foot rule, because they simply will have nothing to do with meters. So there's a margin of error there straight away, and I think there's going to be considerable difficulty about, in professional regulatory terms, insisting on 2-metre rules. Particularly given that yesterday the 2-metre rule was in effect abandoned and we have a 1-metre plus rule now. So I think there's going to be very considerable scope for argument about that. Daniel, do you want to add anything? Carl, do you want to add anything on that?
No.
Well, I would just say that if there was to be an allegation made against a healthcare professional for breaking the 2-metre rule, it's difficult to think of circumstances where that would meet the test of being serious professional misconduct, something that would fall far below what would be expected in the circumstances, because almost inevitably there would be a reason why that the practitioner had broken the 2-metre boundary. So I don't think we're likely to see professional regulatory cases on that topic?
Where we may see it is in provision of facilities for children care, that sort of thing, where premises are not allowed to be opened because you've, inverted commas, not satisfied the 2 metre rule. And that could be fertile ground for litigation. I see the time, and since we promised that we would not keep anyone locked into this on such a beautiful day for longer than was strictly necessary, I think it's probably time to draw stumps unless there are any other matters that people want to raise. I'm not very good at knowing how to turn these things off. Thank you all very much indeed. I'm very grateful for my 2 fellow panelists, particularly Carl, who had to take over just before I started to turn onto the really interesting topic of the Human Rights Act. Thank you very much indeed for fielding that seamlessly. And thank you all very much indeed for your attendance today.